willful men are they, who taxed our cake and took our cake to throw our cake away. The cake grows less and less, for profits lessen too. But land will pay at last, I guess, for land won Waterloo. They mix our bread with bran, they call potatoes bread. And get who may or keep who can, the starved, they say, are fed. Our rivals fatten fast, but we are free to pay. And dearly they shall pay at last who threw our cake away. Well, that is a poem called The Taxed Cake. It is from an old book called The Splendid Village, Corn Law Rhymes and Other Poems by Ebenezer Elliott from 1833. And as the title suggests, it is a poem about the Corn Laws. So the Corn Laws are some of the most hated tariffs in history. Well, we have some of our own hated tariffs today in America in 2025. Now, instead of writing poems about them, however, it seems like we have some litigation. And because of a little judicial engagement, they've been found unlawful. We're going to discuss all this with a tariff expert this week here on Short Circuit, your podcast on the federal courts of appeals. I'm your host, Anthony Sanders, director of the Center for Judicial Engagement at the Institute for Justice. We're recording this on June 4th, 2025, and we have back on the show Scott Lincicome. He is tariff expert extraordinaire at the Cato Institute. And we're going to get to his analysis, his predictions, his whatever about the latest in tariff news and tariff litigation in just a little bit. First of all, I want to introduce my colleague who will be discussing another case later, and that is Jeff Rose, senior attorney at the Institute for Justice and all-round extraordinary litigator, and at this point, preliminary injunction expert, and he'll be discussing that kind of stuff a little later. So Jeff, welcome back.
Thanks, Anthony.
First, a very small announcement before we get to tariffs. We at the Center for Judicial Engagement are partnering with the Liberty and Law Center at Antonin Scalia Law School, and we are putting on a conference. The conference will be next April, and it is on the 250th anniversary of not America, which is everyone else is going to celebrate this year, and we will too, but the 250th anniversary of the Declarations of Rights that many states adopted in 1776. We have a call for papers as part of that. The call for papers is the deadline is the end of this month, June 2025. So if you happen to be a scholar on early American history and constitutionalism, or if maybe you know someone who is into that stuff, maybe would want to write a paper about it, present it at our conference, we have honoraria available to those who are selected, plus travel costs. So please apply. You just have to apply with a summary of what your paper would be, just 500 words at this point, plus your CV. And then if you're selected, you can come to the big dance next April. So I want to put that out there for those interested, and we'll put a link in the show notes. Now, enough formalities. We're on to Scott. So Scott Lincicome is the Vice President of General Economics in Cato's Herbert Stifel Center for Trade Policy Studies. He is famous on many platforms. He is an expert on many things, not just tariffs, but also he is a hot sauce chef. And so if you want to get into hot sauce, we can do that too. But for now, I want to hear what's going on at the Court of International Trade.
An interruption of my vacation is what is happening. Literally, I kid you not, mere hours after I had decamped for a dude ranch in the middle of nowhere in Texas, the ruling hit. So you can imagine my family's delight that I'm on the phone, basically for the first day of my vacation. So that was great. And then there was another ruling the next day, and then the 50% steel tariffs the day after that. I mean, it's, further proof that the president is out to get me personally.
Well, I believe that, but you're back from the ranch now.
Yeah. It was a relatively
So
short.
Jeff has his own Texas ranch. Maybe we can talk
That's
a
true.
little ranches in Texas a little later.
We should definitely dude ranch it up.
Mm-hmm.
So going back to the CIT, it was I think a really shocking decision in terms of its breadth and speed. So basically, last year, I think the best way to set the table is a paper that Clark Packard, my colleague at Cato, and I put together in October. Basically, kind of just laying out the universe of trade laws that the president could use to raise tariffs unilaterally. One of those laws was the International Emergency Economic Powers Act, or IEPA. And this was kind of the bazooka of available laws. There are other laws that are narrower that Trump has used in the past, that he might use in the future, but nothing was so vague and open-ended and dangerous as IEPA. And at the time, we noted that this was probably not the way Trump was going to go, and that legal scholars were really divided on whether Trump could impose tariffs under this and if it was constitutional, all this kind of stuff. But again, we didn't think he was going to do it, and that was the end of it. And then, of course, the very first major Trump trade action of his second term was these tariffs on imports from Canada and Mexico and China under IEPA. And on the guise on the justification that fentanyl coming across our borders was a national security threat, a national emergency. When you declare a national emergency under IEPA, that unlocks these broad trade powers, and we're going to impose a bunch of tariffs. Then in April, we got the Liberation Day reciprocal tariffs, which is what caused markets to basically tank and everybody freak out and all these trade talks and the rest. So along the way, several importers, small importers, and U.S. states challenged the tariffs in several different U.S. courts. And one of those courts was the Court of International Trade. Importantly, I would note, the Court of International Trade deals with tariff cases. It deals with like anti-dumping law and all this kind of stuff, and then customs-related issues. But the CIT was actually the court in which the Trump administration was trying to push all the tariff litigation, because there was litigation out in California and then in Florida and these other U.S. courts in the D.C. District. So the CIT we knew was hearing these cases, but it was really a surprise that it came so quickly. And then the decision itself, sorry, that's a big wind-up, but the decision itself was effectively enjoining the tariffs on the grounds that the president did not have the power to impose global tariffs like he did under IEPA.
Before you get to the opinion, I just want to ask, why was the administration trying to get out of these other courts? Was it because that's some crazy judge that's going to do another one of these nationwide injunctions, and according to international trade, they're pretty buttoned down conservative trade guys who are just going to go with the government probably?
Yeah, and so going back to our paper, one of the risks we noted, because our paper was really just a call to arms of sorts, because we said, look, we don't know how the courts will deal with these tariff laws, particularly IEPA, but others too. And one of the reasons why there was a risk beyond the uncertainty was that the courts had rubber stamped, and mainly the Court of International Trade, but then also the Court of Appeals for the Federal Circuit, which is what's now reviewing the CIT decision. It effectively rubber stamped all of the various tariff actions that had come in the first Trump term. Now, these were under different laws, Section 232 for national security, Section 301 for the China tariffs. But in general, the CIT had been quite deferential, not entirely, but had been pretty deferential. So it made sense for the Trump administration to try to go back to that court. And then again, also they wanted to get to the CAFC, which has been really deferential to the president, because the CIT had pushed back a little bit on a few procedural things, not on much substance, but on the process. And the CIFC then overruled that. So they wanted to get to the CIT, but the CIT then again issued this ruling last week.
Actually, if I recall the opinion, the CIT seemed to say that it actually had exclusive jurisdiction
Yeah.
over this specific, which might also explain one of the reasons why the Trump administration wanted to land there. It was actually legally required to litigate them there. And I think that either a court either a district court in the Ninth Circuit or the Ninth Circuit itself just said, we don't have jurisdiction to rule on California's challenge.
Right. And so this is kind of one of the very lawyerly but preliminary debates in these cases, because some plaintiffs that have been kind of forum shopping elsewhere in the country have said, no, IEEPA is not about tariffs. It is not a tariff law. In fact, one of their main substantive arguments is that the president does not have the power to impose tariffs under IEEPA, and the CIT has exclusive jurisdiction over tariff policy, not over foreign policy. And in fact, the ruling that was issued on the second day of my vacation from the DC District Court actually said that it had jurisdiction to rule for this very reason, that IEEPA was not a tariff law. It talks about regulating commerce, and that allows other courts to weigh in. But in general, so far, there was also, I believe, a court in Florida, and then, like you mentioned, the court in California. They've said, yeah, the CIT has to deal with this. So getting the CIT to issue this, or having the CIT issue the decision, is one of the many shocks. I mean, I think the other big shock was the injunction, or not, at least surprise. One of the big issues in these tariff cases was that, and I think one of the calculated gambles that the Trump administration made, was that it doesn't really help a plaintiff, an importer, very much to win in, say, 2 years if they're paying tariffs the whole time. Because, and this is something the Trump administration denies, but they're wrong on this. Having worked with importers, I can tell you they are wrong on this, is you have to provide deposits for any sort of duties paid. And you have to do it the minute those goods enter the United States, not after you make sales, but the minute they enter. And there are a couple very small exceptions.
That's kind of the same thing where, like, tax injunctions, right? The government says you have to pay the tax and then try to get it back. You can't just enjoin the tax.
Get it back. And so the Trump administration has said, there's no harm here. And that's what you need for an injunction. You guys know this better than I do, quite frankly. But because there's no potential harm from these duties, because they can get a refund. Well, in reality, of course, if you are devoting massive amounts of capital to these deposits, suddenly your banks are not really going to be eager to loan you any money. And there are actually economic studies showing that the minute that companies' ability to access capital is dramatically curtailed when, like, an anti-dumping order goes into effect, and they're even potentially subject to future duties, not even making real deposits. So, but anyway, this was a big question. It was particularly a big question for big companies. So companies that had more access to capital, had the ability to hoard inventories and rejigger supply chains. And so I think one of the creative things that happened in these cases is that the plaintiffs have all been smaller businesses, except for the states, right? And those are the companies that can demonstrate that type of harm, because they can say, look, we only have like 20 employees, or in some cases even fewer, and we don't have the ability to go to share, issue more stock, or go to one of our 17 banks, and right. So that was a big question mark. And so even though guys like me and a lot of others were sympathetic to the substantive arguments around IEEPA, I was not expecting an injunction. I thought this is going to play out over the next couple of years. And so for all of this to happen, in a matter of weeks, was a huge shock. And I think also a shock to the Trump administration.
Right. And, it's worth noting, since Anthony touted me early on as the preliminary injunction expert, it's worth noting that this case is a summary judgment case, which is exceptionally unusual for something to go all the way to summary judgment so rapidly. But just a twist on the remedies thing, in a preliminary injunction, there's a doctrine in which you can get an injunction for financial harms, which normally you can't, because normally if somebody inflicts a financial harm on you, you have a remedy at law. But the United States is sovereign. You can't sue the United States for money in most contexts. And so you can get what otherwise might be a financially reparable injury. You can get the preliminary injunction because of sovereign immunity. But it's interesting, when I saw that this was a summary judgment decision rather than a preliminary injunction decision, I was very surprised by that.
Yeah.
Well, I was going to say too, the other thing I was going to say is what's going on here is something that I've seen in other cases across the country, which is trial courts being both diligent, intellectual, and quick, because a lot of these challenges are raising, issues that haven't been well litigated in the past, that certain policies of the Trump administration are particularly aggressive versions of executive authority. And so, and lower courts recognize that these have to be dealt with expeditiously by the courts of appeal and possibly the Supreme Court. And they're actually burning midnight oil on this.
Yeah. Yeah. And I would add that on the economic side of things, recognizing the damage or immediate, potential or immediate damage that these tariffs cause American companies is pretty great from my view, because it just wasn't clear to me, at least, that we were gonna get that type of acknowledgement. So going back to our other tariff debates, it's proof again that Americans are paying these tariffs, right?
Right. Right. It's not, I mean, in the common perception, it's like, when you're, the great thing about tariffs is, China's a bad guy and a tariff is a way of hitting the bad guy on the head with a stick. But what you're actually doing is hitting an American on the head with a stick, and that has a downstream effect on the Chinese supplier or something like that.
Yeah, yeah. And coincidentally, and adding to the comedy of my vacation interruption, the plaintiff in the DC District Court case was actually a small business owner that I interviewed over at the Cato website. And we have a video of it, a guy named Rick Woldenberg. He owns a educational toy company. And so Rick and I talked at length about the real financial difficulties that these tariffs put his company in. He said that they basically had to cut their entire ad budget, stop building a new warehouse, and do all of these other things to just try to stay afloat while the litigation was pending. But Rick and I talked in April, and he really had very little, and he's a very optimistic guy. I think you have to be at this point. But even Rick had very little confidence that he was going to get a resolution so quickly. Yeah. And so it was really a stunning and wonderful development.
So it seems like we have this final judgment. It is being appealed. I know it's been stayed by the federal circuit, but eventually it will get ruled on at that court. It seems like the meat of the analysis is that there's this super broad language, and it's kind of a don't hide elephants in mouse holes kind of argument, to quote Justice Scalia, under maybe the Major Questions Doctrine, maybe the Nondelegation Doctrine, but the opinion never really differentiates between the two, which I know some other commentators have talked about that, but in my own read, it kind of raised a question mark, like, there's a little bit of hand waving here, maybe. Yeah. That's going to need to get fleshed out by the time it gets, eventually to the Supreme Court.
Yeah, and I gladly defer to y'all on some of this stuff. Having abandoned my bar license years ago, but I agree that it seems that their desire for speed and getting this done sort of trumped, no pun intended, some of those details, and I'm sure they will get fleshed out.
Well, and one of the things that was interesting about this decision is that it was a running study in a contrast with a prior statute about emergency war powers that had existed since the early 20th century. And then President Nixon apparently had invoked them at one point, and Congress reacted in the early 1970s, and then I think it was subsequently amended. But one of the things that the Court of International Trade said is the emergency war powers thing was super, super broad. And then it was exercised by President Nixon in a way that Congress didn't like. And whatever this statute is, it is necessarily narrower than that war powers thing. And what's going on here looks an awful lot like whatever happened in that war, what President Nixon was trying to do, getting us off the gold standard, et cetera, in those days. And so, to me, I looked at this, and what the court seemed to be saying is, I'm not sure if this is major questions. I'm not sure if it's non-delegation. We're going to interpret the statute so as not to run afoul of those doctrines, excuse me, whatever they might say, and interpret the statute in light of this predecessor statute. And it kind of comes out as this sort of smudge in the middle that says, it feels like the president is in that smudge somewhere where this is against the rules.
Yeah, and the other key point is that following the Nixon actions, Congress not only reformed the Trading with the Enemies Act to create IEEPA, but it also created this other provision of law called Section 122, which allows for a blanket tariff for what they call balance of payments reasons, which is like the trade balance and other things, right? So emergency. So the court is basically saying, and I should note that the reciprocal tariffs that Trump is trying to implement here, the Liberation Day tariffs, those are all premised on a balance of payments crisis or emergency. The trade deficit being a big emergency. And so that's, I think, the other really strong, I think that is one of the strongest arguments against the use of IEEPA to impose at least global tariffs like this, is that no, there's another law that kind of came out of this previous version of IEEPA and the Congress's view on this, and that's what you should use if you want to do this. And you're not using it, and that's a problem.
That was interesting. So I didn't know the background about, I knew about when the US went off the gold standard in the early 70s, and it was because of, the excuse was this balance of payments thing. And it does seem odd that you would have what essentially seems to be kind of a foreign policy military statute to do that balance of payments stuff.
Right.
And any other thoughts about how, the Supreme Court or the Federal Circuit are going to look at these matters a little differently? They usually don't have their toe in the waters of tariff policy, but they do think about executive power and balance, how this goes with other major questions doctrine cases and all that.
Yeah, I'm given how the CAFC has ruled in other Trump tariff cases previously, I'm pretty skeptical. I want the plaintiffs to win in these cases, but I'm pretty pessimistic about the CAFC's review of these decisions. And I think the more likely victory is going to come at the Supreme Court. Given how the current court looks at executive power, has a toe in non-delegation stuff, right? And has major questions doctrine, support. It seems that that's where victory lies. The CAFC, to give you an idea of just how deferential the CAFC has been in tariff cases. I should
say that the CAFC be the Court of Appeals for the Federal Circuit. So it's like this specialized Court of Appeals that gets Court of International Trade, patent stuff, other things. Yeah.
Maybe the Federal Tort Claims Act in certain situations or something like that.
Yeah, Court of Claims cases, I think. Yeah.
Yeah, and so the CFC has looked at several, because the CIT has not just uniformly rubber stamped Trump tariff cases. It hadn't been great, but it hasn't been. It has pushed back a little bit. And in one of these cases, the two cases I would bring up is the first one, the Trump administration just out of nowhere upped the tariff on Turkish steel from 25% to 50%. But they did it well outside of the statutory time frame for setting the original tariffs. And the Court of International Trade just looked at the statute and said, yeah, you can't do that, right? It's a deadline's a deadline. You missed the deadline. You can have 25% tariffs for as long as you want, but you can't just up it. CAFC shot that down and said, no, actually, the law says adjust somewhere in there and you can do that, right? And of course, me and my colleagues immediately were rolling our eyes, gasping. But that's one. The other one, which is similar decision, is that the CIT said that the Trump administration could not expand the tariffs to cover downstream steel and aluminum products, what they call derivative products. And this was, again, based on the text of the law, which had strict limits on when you could set the tariffs and the scope of the tariffs and all this. And again, the CAFC said, no, that's fine too. So given that background, and then some stuff on Section 301 as well, I'm not extremely optimistic about this next stage of things. I think more likely victory lies with the Supreme Court itself. But I should note, IEEPA is a different statute. The tariffs here are really different from what we're talking about with steel and aluminum, and even with the China Section 301 stuff. So maybe I'm wrong, but it seems I'm right.
Yeah, I would say, sort of before we shift gears, the other thing that's a little troubling for someone who's a liberty litigator is the emergency, in quotation marks, nature of this, just in general, that when we give government authorities broad powers to declare emergencies, one of the things they like to do is declare emergencies that last for a long, long time, and they keep getting renewed. And in this case, 35 pounds or something worth of fentanyl was intercepted at the Canadian border. And so suddenly, American businesses that are importing breakfast cereal made from Canada have to be hit on the head because of this. And this just all feels a little bit not quite like an emergency.
Right. And I would add that this was another reason why the courts have generally been okay with this broad emergency power, even though the folks on this podcast aren't. And that was and the CIT even there was skeptical of some of the emergency declarations.
Right. And like what could be more cliche than the leader saying, "You must suffer, my fellow citizens, because nefarious foreign powers are doing things, and only my strong fist."
Especially Canadians, Jeff. I mean, you know about those guys.
I do. I grew up in Canada.
And the trade deficit one is similarly ridiculous, not just for the economic reasons. I mean, any economist worth his salt will say that a trade deficit is not necessarily a problem economically. But leaving that aside, we've had a consistent trade deficit for 30 plus years. So how is it an emergency by any legitimate definition? Has it just built up? It's built up over 30 years and suddenly the dam is broken? No, it's ridiculous.
It's the meme out of The Incredibles. When everybody is super, nobody is super. And if this is an emergency, then everything's an emergency.
Isn't that there's something like there are dozens of declared emergencies at any one time in the executive branch.
The city of New York declared a rent control emergency following World War II when all of these ships arrived with soldiers coming home from Europe. And that emergency has been continuously renewed for whatever, we're going on 70, 80 years now.
Whatever emergency it may be, kudos to our friends at the Liberty Justice Center and Jeff Schwab and a few other lawyers, including your colleague Scott, Ilya Soman, who are litigating this case, and best of luck to them as they go up the chain. So we're going to move along our chain now to the DC Circuit. We're talking like a premier appellate court here, which for some reason, when Jeff first suggested this case to me, I thought it must be the Fifth Circuit because it has Ken Paxton, the Attorney General of Texas. But it's kind of like some extracurricular stuff he's been doing is why he's there. And this case involves him and Elon Musk and Twitter and Nazis and Media Matters and a subpoena. That's not really a subpoena. So what's going on?
Yeah, well, everybody who uses the internet, which we are now, has to talk about Elon Musk at least once a day, and so that's what we're doing. So this is a fascinating and sinister case. In November 2023, Media Matters, which the DC Circuit describes as a nonprofit media watchdog, they published an article by an investigative reporter of theirs that said that two things. Number one, that Elon Musk had endorsed an anti-Semitic conspiracy theory. And then number two, that ads for, as American as apple pie companies like Apple and IBM were appearing next to anti-Semitic content on X, formerly Twitter. And a few days later, Musk said that he was going to file a thermonuclear libel lawsuit against Media Matters, and he did. And then a few days later, Ken Paxton announced that the Texas Attorney General was going to do a consumer protection investigation under a consumer anti-fraud statute, the kind of thing that you would normally use to go after someone for selling defective air conditioners, that they were going to investigate Media Matters for publishing an article with falsehoods, as though an article involving core political speech with potential falsehoods is the equivalent of a defective air conditioner.
They both blow a lot of air, so hot air, maybe.
Yeah, that's a good point. The press release characterized Media Matters as a radical anti-free speech organization, and decided to protect the principles of free speech by hitting Media Matters with a sweeping document production demand for all things related to Elon Musk and X and all this kind of stuff. And so they, perhaps unsurprisingly, shortly thereafter, filed a Section 1983 suit against Ken Paxton in his official capacity, saying that you have retaliated against us in violation of the First Amendment because we engaged in core political speech. And the reason why I say that this is a sinister case is that the Attorney General's objections were primarily procedural, but to the extent that they were procedural, they were premised on the idea that because this article contained falsehoods, the article was a defective consumer product and not subject to the protections of the First Amendment. Now, that was the Attorney General sort of barely defended it, and the DC Circuit quickly disposed of it. But the implications of this are really significant because if you take this theory to its logical conclusion, if a political article or a form of political speech with false factual assertions in it is not protected by the First Amendment, generally speaking, then that's not just a kind of consumer protection thing. You could impose all kinds of penalties, the sorts of penalties we impose for unprotected speech in other contexts, like conspiracy or fraud or child pornography. And the DC Circuit recognized that this was a sweeping and dangerous thing, that it is very difficult to bring some kind of retaliatory action against free speech, and they shut it down pretty quickly. But the main argument was that merely investigating someone, even a sweeping investigation, wasn't a cognizable claim. Because you really shouldn't have your speech chilled by an investigation, or at least not an investigation for a kind of document demand that you could otherwise challenge in court.
So one thing that also got me thinking pretty sinister things was that not all the judges even agreed that Media Matters could challenge this at this point for most of what they're alleging is harmful. And right. That's when I read it, I said, well, they have to comply with this subpoena. I thought, well, that's your harm right there, right? Because you got document production, right? But Judge Henderson in the concurrence said that's not harmful. That's not standing. And I guess it's because there's this alternative way that you could maybe meet it, or maybe it's not even required that you respond to that. She said that there's also allegations they have that their contacts with other entities are being harmed by this threat. And so that was enough for standing at this stage of the case. And so that's why she concurred and didn't dissent. But it still struck me as kind of scary that itself isn't a cognizable harm, that you're required to respond to this subpoena.
Well, it seems particularly crazy when the Attorney General of a state as large as Texas teams up with the world's richest man to go against a nonprofit organization explicitly based on disagreement with its viewpoint. That just seems so obviously in the core of the First Amendment. And, like I say, it may be true. Elon Musk has his separate libel lawsuit going again. Like, if the speech is libelous, then the speech is not that, then, at least the assertion about the anti-Semitic conspiracy, if it is indeed libelous, then it is not protected and he can get damages for that, whatever they are. But what the court found here is that the Attorney General's actions were not actually about libelous speech. It was a bad faith action against Media Matters to punish it, to retaliate against it for its viewpoint-specific speech. And that is a separate issue from libel. And that's why I say this seems actually quite sinister. Now, it's true that the court disagreed a little bit about the nature of the injury for the claim, and I was surprised that they kind of quibbled over certain things. I mean, Media Matters quite plausibly said we've changed the way we're writing, we've changed the way we're investigating, we have concerns about reporting, all these kinds of things. And to say that, well, technically it's possible that you could have ignored this and then waited for a court order in a Texas court or something like that, and therefore your injury isn't entirely ripe or complete right now, that actually seems to really miss the point. That in the United States, when a state as big as Texas, or really any state, teams up with the world's richest guy to suppress speech on the basis of viewpoint, that's something that should concern everybody.
Well, Scott, I know this doesn't have to do much with tariff law, but this is definitely a trend we're seeing. We at IJ deal with across the country about retaliation and using the offices of government to do such things. I would think there are certain tariff matters, certain investigations that are made in that regard that don't have much to do with economics and have a lot to do with retaliation of certain kinds. Does it raise any cockles for you?
Yeah, I mean, I think the clearest example that recently came up was with Apple, right? So Trump doesn't like the fact that Apple, instead of making iPhones in America for some reason, he wants they're going to make them in India, and he got really mad at that and said he was going to slap a tariff on iPhones. But I should note that when it comes to taxes and other economic measures, there seems to be a little more discretion, at least on behalf of the government lawyers, because very quickly after Trump said that, he and others in the administration said, no, it would apply to all smartphones, not just Apple smartphones. So it does, occasionally we have these cases, but because you can kind of broaden it out to a certain product, and even one that's overwhelmingly made by a certain company, they tend to try to navigate around it, which it seems a lot different than what's happening with Media Matters.
I would think too that when certain foreign policy actions are untested, right, at the Supreme Court versus all kinds of domestic actions when it comes to Bill of Rights issues, equal protection, right? And we saw that very much with the Trump via Hawaii case, where it clearly seemed like there was some kind of free exercise problem here, right? That at least the language coming from Trump when he first came into office was you were going to shut down Muslims coming into the country. And of course, that's an equal protection or First Amendment issue. But then you have the traditional powers of immigration and all the foreign policy stuff. And it basically, the court was able to get rid of that. How it got rid of it, we don't have to go into that. I would think if the First Amendment and tariffs came to a head, unfortunately, there would be a bit of judicial abdication there to try to not have that come together, because then you have the courts telling the executive what to do with foreign policy, which is going to be hard.
And maybe like you could actually have a judicially engaged decision that would cut in the president's favor in all sorts of ways when it comes to foreign policy and dealing with, I mean, it's reasonable to be pretty agnostic, but when I see something like this, which is core political speech by a left-wing liberal, and I don't have any particular opinion about whether their speech is good or bad or right or wrong. That's irrelevant to me as a First Amendment lawyer. What we have is an investigative reporter publishing a piece on a prominent political figure and suffering almost immediate retaliation from a government entity that is, closely associated. I'm broadcasting today from the city of Austin, Texas, and both Elon Musk and Ken Paxton live here, and they're both close allies of the president and President Trump, and they were with he wasn't then the president in 2023, but all kind of part of the same complex and part of a larger sort of move against social media and certain kinds of, I think, modes of expression that have happened in recent years. So anyway, this seems very concerning to me. And like I say, just the sheer disingenuousness of using a consumer protection statute, and then also making an argument that feels right at home in Russia, which is something like, comrade, we have complete freedom of speech in Russia. We love all opinions except false ones, and yours is false. And so yours doesn't get any protection, comrade. And that's why you are here today in court, in a cage.
Got to protect those consumers, man.
Yeah. This is not the direction we want our country to be going.
Well said. Well, to close out today, we're going to have a quick episode of Where Are They Now?, where some of our hardcore listeners want to know, what you talked about that case 3 months ago. Like, what happened with it? Well, we got a very few set of updates. One is a case we talked about almost a year ago, McCrae versus Matos from the First Circuit. This is the case about a woman who was a public school teacher and was fired or disciplined, forget which, I think fired, because of some social media she did before she was hired. They basically found it after the fact. It has now been relisted at the Supreme Court 8 times and is up for a conference tomorrow as we are recording this. So maybe by the time you listen to this, it'll all be old news. But that portends that something's going to happen in that case. And the court, it's taken other cases in that vein lately. So it could be they're going to vacate it and remand it. It could be they're going to do something else. Another case I keep updating from time to time is the case from the 11th Circuit, Gilmore versus Georgia Department of Corrections, about a strip search in jail. That has been waiting of someone who was visiting the jail and was not themselves an inmate. We're still waiting on. It was argued in February before the en banc court. And an IJ case, Thomas versus County of Humboldt. This is a case that we won recently at the 9th Circuit, and one of our attorneys came on and talked about it. And that is the case about people who had ruinous fines in the millions of dollars threatened against them because satellite photos made it seem like maybe they were growing marijuana when they were not. We have actually asked for cert in that case on one issue, the one issue we lost, and that is whether the 7th Amendment, the right to a jury trial in a civil case, applies to the states. And it's getting some buzz. People are writing about it. So anyway, that is now pending at the Supreme Court. We'll see if the court asks for a response. Time will tell if that makes it to the court, and we do another episode about it in the future. But for now, I would like to thank Scott and Jeff for coming on. Scott, I don't know if you yourself write poems about tariffs, but perhaps we've given you a little inspiration for the future.
Yeah, we used to do trade Valentines on Twitter, but ChatGPT has ruined it because ChatGPT is just so good at doing silly little poems instantly that, you just don't know if somebody's actually thinking of these things themselves or if it's just the bot.
That's terrible. Well, you still come up with your own puns, I see from time to time.
That's true. No, I haven't given outsourced that to AI just yet.
Okay, well, that's good to keep in mind. I actually, to come up with that poem, which that was a real poem from a real book, I actually did try to use ChatGPT to tell me, and it came up with a quote from supposedly a Charlotte Bronte novel. And then I looked the quote up and it was made up. It was not actually from Bronte.
Yeah. A lot of problems with that in the policy world these days.
Kids, don't use AI at home or in class. In other news, we will see everyone next time. And for now, please be sure to follow Short Circuit on YouTube, Apple Podcasts, Spotify, and all other podcast platforms. And remember to get engaged.